Hi, Alecia Hall, estate planning and probate attorney. If this is your first time visiting my channel, please don't forget to like, subscribe, and of course, always comment. Don't forget to click on the bell so that you will be notified as soon as I upload new videos about estate planning, probate, and building and protecting your legacy. In this video, I'm going to talk about living trust and specifically what happens to your trust after you pass away. So let's talk about your living trust. You've created your living trust and you have, let's say you have real estate property, maybe you own a business, and you have some other investments. And all of these are actually in your trust. If you've watched any of my prior videos, you know that I say to think of your trust as a box. If you don't put anything in your trust, all you're leaving behind is an empty box. When you put things in your box, it's called funding your trust. So in this scenario, we have properly funded our trust. In addition to the assets that you've already put in your trust, let's say you have a few other assets that are not in the trust. So maybe you have a car and one checking account with a balance of about $20,000. So once you pass away, everything that was already in your trust is going to avoid probate. Also, when you pass away, your trust is going to become irrevocable. Can't make changes. It's irrevocable. You're no longer here. You can't make changes to it. Your successor trustee is going to step into your shoes and they are going to take over the management of the assets in your trust. Now, in the beginning, when we were talking about what's in your trust, I mentioned that you have a business that is in the trust. And maybe even your real estate is actually owned by an LLC or an INC. For businesses, if you have an LLC and you have an operating agreement, or you have an INC and you have bylaws, and they properly have instructions for what happens when you pass away, those governing documents are going to control what happens with the business going forward. So make sure that 1, you have corporate governing documents, and 2, they have instructions that you want to be followed when you pass away. For the assets that were not in your trust, remember I said you have a car and you have about $20,000 in a checking account. Those assets are going to have to go through probate. But because the value is below $75,000, yes, we're assuming that the car is not a Lamborghini. So you're below $75,000. Here in Florida, you're going to qualify for a summary administration. It is a faster process and it's less expensive. Most likely, your estate plan, in addition to the trust, it also included a pour-over will or a will. What a pour-over will does is it says, whatever assets I have, I want them to be transferred into my trust when I pass away. You can have other instructions in that will. It doesn't have to transfer everything into the trust, and it doesn't have to transfer anything. It doesn't have to be a pour-over will. But the point is, you've also created a will that directs what happens to the assets that are going to pass outside of probate. The fact that probate is going to be required is not the end of the world. In fact, whenever I have clients that come to me, their loved one has passed away and they have a trust, I always recommend that we open probate. And here's why. The number one reason why I recommend opening probate is to deal with potential creditors. Here in Florida, our creditors have a 2-year statute of limitations, and your creditors actually can open probate on your behalf. So even if your loved ones never get around to opening probate, your creditors can. If probate is opened, one of the things we do is we publish a notice to creditors. We also contact directly any creditors that we already know exist. In doing so, we actually are able to cut that 2 years down to 90 days. And if the creditor does not file a claim in the probate case, and they were, in the case of a known creditor, they were served with notice, or in the case of unknown creditors, they had the 90 days, guess what? Their claim is gone. So this is why I always recommend to still go ahead, open probate just to deal with the creditors. That way, your loved ones are not looking over their shoulders for the next 2 years, wondering if a creditor is going to drag them into probate. Also, if you have minors that need to have guardians appointed, that should be dealt with through the will. So make sure that if you have minor children, you have language in your will that outlines your wishes for who you would want to step into your shoes and take care of your minor children. Because if you don't include that language, there's going to be a lot of guessing. Everyone's going to guess and possibly even argue about who should have custody of the child. and your preference will not be taken into account because you failed to provide us with your preference in writing in your will. Okay, so back to your living trust. Once you pass away, 3 things are going to happen. First of all, your trust is going to become irrevocable. Second, your successor trustee is going to step into your shoes and take over as the trustee and begin to manage the property. And the third thing is, we're going to begin a process called trust administration, which is administering the trust. From here on out, the assets in your trust are going to be managed by the trustee that you designated in accordance with your instructions. Typically, your trust is going to provide for the care, maintenance, education, and health of your beneficiaries. But you can add other instructions, other restrictions, and other directions in your trust. It's up to you to create your trust and to build out the language that you want for your trust. Your trust might actually also include sub-trusts. And so think of these as baby trusts. So with a baby trust or a sub-trust, what's happening is you have your Papa Trust, and the assets in your Papa Trust are going to be distributed into these smaller trusts. And these assets are going to be distributed from the Papa Trust into the smaller trusts in accordance with your instructions. So let's say, for example, you have several children and you want to make sure that you leave specific property to each child. But you don't want the trust to become extremely complicated and have maybe 100 potential beneficiaries as we go further down the line in your grandchildren, your great-grandchildren, because we're hoping that we're building a trust that's going to last through the ages and through the generations, right? So what you would do in that situation is you would create these sub-trusts. Another thing to think about is what happens if you have an incapacitated child? And this could be a minor, or it can also be an adult that is not able to care for themselves. Your trust should have specific language that makes sure that if that individual is already receiving government benefits, they don't lose those benefits. Or if they are potentially going to receive government benefits, we don't want them to lose eligibility in the future to earn or gain that government benefit. So we're protecting them. The last thing you could possibly want is for your beneficiary to suddenly inherit. And let's say they were already collecting government benefits. Maybe for 10 years they've been collecting government benefits because they're incapacitated. The one thing you do not want to happen is for the government to step in and say, oh, she has money now. Hi, we're here and we're going to collect everything we've paid out over the last 10 years as a reimbursement. And to avoid that from happening, because it does happen, you want to make sure that your trust includes special language. It's a special needs language specifically. And what it does is it protects that beneficiary and it makes sure that they can either continue receiving government benefits or it will not prevent them from becoming eligible from receiving government benefits in the future. Before I wrap up, I want to talk a little bit about your trustee. Make sure that the person you are naming as your successor trustee is, first of all, someone you trust, but also someone that you know you can rely on to make reasonable and rational decisions. Because this is the person who is going to be handling and managing the affairs for your loved ones going forward. This person, depending on your instructions, might, for example, be the one who is going to decide whether your son is going to be getting that $40,000 car that he wants versus maybe a reasonable, smaller, less fiery, less sexy car that will get him to school and back or to work and back. Another example of something your trustee might need to make a decision about, depending again on your instructions, is whether the school little Johnny wants to go to makes sense. If Johnny decides that he wants to go and spend $300,000 going to an art school, maybe that's not the best decision. And the trustee is going to be the one who is going to make the ultimate decision. So make sure that you really think about who you are going to name as your successor trustee. If you are a resident of New York, New Jersey, or Florida and would like to discuss creating your living trust, click on the link below to schedule your estate planning consultation. Please don't forget to like, subscribe, and click on the bell so that you will be notified as soon as I upload new videos about estate planning, probate, and legacy building.